Yeah, with the consent Tushar bhai, can you please switch on your video?
Yes, sir.
Yeah. So, with your consent, should we start?
Please, sir.
Yeah. Respected President of Southern Gujarat Chamber of Commerce and Industry, Vice President, Secretary, Treasurer, Secretary is about to join, is stuck in some traffic, and immediate past President Ramesh Vagas. From the ITT Bar Association, Surat, we are awaiting Suresh Kabra, and in his place, we have Group Chairman and a very eminent Chartered Accountant, Mitesh Modi, with us. From the South Gujarat Income Tax Bar Association, we have Anil Bhai Shah, we have Vice President Ms. Ashish Vakil, Mr. Dipesh Shakwala, and from the Judges Corner, a wonderful advocate personality, Viresh Rudalal, is with us. So I request the immediate past President of Southern Gujarat Chamber of Commerce and Industry, Ramesh Bhai Vagasia, to give his welcome address. Unmute. Ramesh bhai, please unmute yourself. Unmute karo. Ramesh bhai, you need to unmute yourself. Yeah. Now you are.
Am I audible now?
You're perfectly audible.
Thank you. Thank you, sir. SGCCI, the Southern Gujarat Chamber of Commerce and Industry, is enough fortunate to have today a learned speaker, Mr. Rajiv Bansal ji, to guide our members and participants today. I would like to welcome Honorable learned speaker and our guide, Rajiv Bansal ji. You are most welcome at this platform, and we are happy to welcome you and very eager to learn something from you. We have our Vice President, Mr. Nikhil Madrasi, Income Tax Committee Chairman, Mr. Pragnesh Bhai Jagashet, our team member, Group Chairman, Nitish Bhai Modi, Viresh Bhai Rudalal, Ashish Bhai Vakil, Kishore Bhai Giwala, Anil Bhai Shah, our beloved hard worker, Dipesh Akwala, and all the participants of the day. Today, this session has been organized collectively by not only SGCCI, but ICAI's Surat branch, ITAT Bar Association Surat, South Gujarat Income Tax Bar Association, SGFTC, TGCTC, and Income Tax Bar Association, along with support of all the team members of Income Tax Committee and our leaders and senior members. All participants are all most welcome here. Sometimes what happens in law, especially in income tax and taxation laws, that something is to be added and something to be did on that base. Papers feels very, very confused and disappointed to how to understood that and how to implement that. So on the points of reopening of some cases in income tax, it happened before 2 years, and it goes to be continue. On the base of that, Supreme Court has given an judgment, and it became the marvelous to understand. So this is opportunity today to know each and everything from every corner of this judgment from Honorable Rajiv ji. Once again, I would like to welcome and thank you all who are cooperative here. Thank you very much.
Thank you very Thank you very much, Ramesh Vagasia ji. I hope you are enjoying your Diwali early, so you have not been here physically. That's very nice. We have with us the young, dynamic and agile young secretary of Southern Gujarat Chamber of Commerce and Industry, Nirav Mandlewala ji. A few words from him, please.
Good afternoon, everyone. I would like to welcome our esteemed speaker, Senior Advocate Tushar Hemani, the Senior Counsel from Ahmedabad. Sir, since Ramesh Bhai have already given the welcome speech, I would just like to inform you about the Southern Gujarat Chamber of Commerce and Industry. The Southern Gujarat Chamber of Commerce and Industry is one of the oldest chamber of our country, which was established in year 1940. Our territory begins from Bharuch to Umargam, and around 150 plus organizations are members of this organization, and more than 12,500 members are there with this organization. A part of industry, we always keep the dialogues on the topics of income tax regularly and other pertaining subjects. And as a part of this, today's program has been organized with various organizations. So I won't take much time. I would like to welcome you, and I ask Pragnesh Bhai to carry forward.
Thank you very much, the young and dynamic Honorary Secretary of Southern Gujarat Chamber of Commerce and Industry. It's always a very positive and a very pleasant sign to the eyes that a young and dynamic person is leading the chamber, and that's the future of chamber is very nice because of such young and dynamic persons in Surat and the southern part of this country. Now I request the President of the ITAT Bar Association Surat, who have been very kind enough. Let me be very frank that ITAT Bar Association is such an association who wanted to take the lead for this program. But then when I requested Kabraji that let the Southern Gujarat Chamber of Commerce and Industry take the lead and we all should follow them. So he conceded that it's always a pleasure being a part of the Southern Gujarat Chamber of Commerce and Industry. So I, for the introductory speech from the ITAT Bar Association and to the members of the ITAT Bar Association, over to the President, Suresh Kabraji.
Good evening to all. Tushar bhai, welcome on this meeting. We would be very grateful also, and we'll have the knowledge sharing with you, from you rather, because you have been present in the Supreme Court itself and you have argued this case also. And now with this decision of this magnitude, which is affecting pan-India, and so much penetrating in the working of all the chartered accountants and other professionals. So this will definitely, with your good words and with your all in-depth study of this case, will definitely appraise all the professionals how to deal with the individual matters, because the decision is in such a way that has many facets. It's not a one-liner like Ashish Agarwal that, okay, 148 AB decisions disseminated and matter goes away. But here there are a lot of facets, 3 years, 6 years, 10 years, then sanction of 151, then the surviving period and the stay period. So you have to be from pillar to post, you have to run and find out that which side of the decision is affecting my case. So each case has to be separately seen, and with your wisdom and with your detailed analysis, definitely all the professionals will be having and helping guide in taking care of their own cases. So that way it will be a very good meeting, and Chamber of Commerce, Nirav Bhai Mandlewala is here, and other friends, Anil Bhai, Kishore Bhai, Dipesh Bhai, Viresh Bhai, Ashish Bhai, and then Mitesh Bhai, all are here and will be definitely benefited in the question answer also. So we may ask you certain questions, and if that will be definitely useful for the fraternity as such, and that will help us. So always welcome, and let us continue with your talk now onwards as per the agenda with Mr. Pragnesh, who is always with me as a secretary. So he has been very active in working the Bar Association. Thank you.
Thank you very much, President of ITAT Bar Association Surat. Now, obviously, there are many organizations, so every organization would like to invite and welcome their members. From the South Income Tax Bar Association, we have Ashish Vakil. I request Ashish Vakil to welcome their members, please.
Thank you, Pragnesh bhai. I think Kabraji has covered everything, and without ado, I think we should go ahead with the program so that our valuable time of our fraternity uh, don't get wasted. Thank you very much.
Rajneesh bhai, excuse me.
Yes.
Sorry, I apologize. I wrongly pronunciated Hemani Saab instead of Hemani Saab, Rajiv ji. I'm
No,
very
no,
sorry.
He
Yeah.
was
If
very
I-
happy
if I am
because
Rajiv
he has got
Bansal,
all the,
I-
he has got
Okay,
all
all
the
participants
publicity.
Is the
will
case?
get
I'm on the highway traveling
Yeah,
from Bharuch
Yeah,
to
yeah.
Surat.
Yeah.
I'm
So I
sorry.
Yes, yes. I request the co-chairman of Income Tax Committee, Southern Gujarat Chamber of Commerce and Industry, Anil Kesha, to please give something about the program.
IPP Ramesh bhai Vagas, Chairman of Income Tax Committee Sri Pragnesh bhai Jagaset, Co-Chairman Sri Dipesh bhai Shah, Dipesh bhai Shakwala, Kishore Giwala, Advisor Sri Videsh bhai, and Group Chairman Sri Mitish bhai Modi, and office bearers of all the association who have joined in this webinar, and friends. First of all, I from bottom of my heart welcome our speaker Sri Tushar bhai Himani. Sri Tushar bhai will deeply analyze the recent verdict of the Supreme Court on a very sensitive issue under Section 148 in the case of Rajiv Bansal. The issue before the Honorable Supreme Court were whether TOLA, that is the taxation and other law amendment, will also apply to the notice issued after 1st April 2021. And another issue was notice issued under Section 148 of the new regime between July and September 2022. The Supreme Court favored the department, and it will impact the fate of the 90,000 income tax notices. While giving the verdict, Honorable Chief Justice Sri D.Y. Chandrachud overruled all the judgments delivered by Gujarat High Court, Allahabad High Court, Orissa High Court, and Delhi High Court. This landmark judgment is ruling regarding the extent of executive powers to extend the limitation via executive orders, even after the new legislation has been enacted. This judgment has opened Pandora's box, and huge piling litigation will occur. In the present judgment, Honorable Supreme Court has accepted the Income Tax Department's argument and held that the TOLA is applicable. Sri Tushar bhai Himani, a senior advocate and my guru, will dissect and analyze the judgment, and I hope you will gain a lot from his discourse. Thank you.
Thank you so much, Anil Besha. It's always a wonder and pleasure to hear from you. You covered the whole about the topic very wonderfully well. Now, for the introduction of today's speaker, though we all know that Advocate Tushar Hemani does not need any introduction, but I request Vice Chairman of Surat branch of ICAI, Ashwin Bhawala, to introduce Advocate Tushar Hemani.
Thank you, Pragnesh sir. Thanks for giving this opportunity to introduce such renowned speaker and senior advocate Tushar Hemani sir. Senior advocate is a senior advocate practicing in the field of direct and indirect taxation, corporate, commercial, and fiscal laws before Honorable Supreme Court, High Courts, tribunals, commissions, and other judicial authorities. He is one of the youngest at bar to have been conferred senior designation by the Gujarat High Court in the year 2019. He is Vice Chairman of ITAT Bar Association's Coordination Committee of All India Federation of Tax Practitioners for the term 2023. President of Income Tax Appellate Tribunal Bar Association, Ahmedabad for the term 2015 to 2017. He is also a member of Direct Tax Committee of Gujarat Chamber of Commerce and Industries. Also member of Legal Committee of All Gujarat Federation of Tax Consultants and Legal Committee of Income Tax Bar Association. Sir is also nominated as a subgroup member of Direct Tax Committee of WRC of ICAI for the year 2018 and 19. He is a regular speaker at various conferences, seminars, and meetings of varied professional bodies on diverse issues in the field of taxation and corporate laws, He is a regular writer of columns, articles, and papers for professional journals and conferences. He is a visiting faculty at various institutes, universities, colleges, management, and law school on the subjects of taxation and corporate laws. With this beautiful and brief introduction, I welcome Tushar Hemani sir. Over to you, Pragnesh sir.
Thank you very much for a very wonderful introduction. The mic and the floor is all yours, Advocate Tushar Hemani ji.
Good afternoon, friends. The dignitaries of various associations, their office bearers, and many friends. I'm grateful for this opportunity. Anil bhai said Pandora's box. It is in fact a Pandora's box. In the Greek mythology, there was a character named Hesiod. Hesiod was a very curious woman. And there was this box which her husband left in the house and no one was allowed to touch it. Because of her curiosity, despite repeated warnings by the husband, she opened that box. And as the mythology goes, it goes 700 years BC, that it released various curses upon the mankind. Probably something similar. I would not say these are all curses. These are, for lawyers, it's a bread and butter. Maybe for SSs, it is a nightmare. But it's like going to a hill station. And, when you go for a trekking in a hill station, that person will tell you that, sir, wahi bas wo pahad ke upar jana hai. You start walking, you realize that ye chota pahad climb kar lenge, then probably we will reach there. Once you climb that small mountain, you realize that there is a bigger one ahead of you. Once you climb that slightly bigger one, you realize that there is a third one ahead of you. So we all thought that we are nearing the end when Supreme Court started hearing Rajiv Bansal. And Ramesh bhai, mind you, I don't want to be Rajiv Bansal because all these participants will beat me if I am Rajiv Bansal, because I have given sleepless nights to many. When the Rajiv Bansal started happening before the Supreme Court, we all thought that this is going to be the end of the matter. However, the very fact that we are all gathered here and discuss, analyze, and interpret the judgment itself is a testimony to the fact that Supreme Court has not solved the problems. Had it been the case that Supreme Court has solved the problems, then probably we would not be gathering here. We would not have gathered here and discussing the interpretation of the judgment. It's an ironical fact that we have to interpret a judgment so as to reach to the conclusion, which is otherwise very apparent. So with this brief background, let us go to the topic per se, because I have exactly 45 minutes with me. So by 5-7, probably I should be finishing. And thereafter, probably some question answers. Idea is to cover as many controversies as possible so that we do not have so many questions. But I'll try my best to cover all the angles. What I plan to do is, I don't want to discuss something which is general in nature, because this judgment has laid down large number of laws, that what is the significance of assessment, what is deeming provision, how the law is required to be interpreted, so on and so forth. So we'll leave aside those general principles. We will only concentrate on the issues which are pertaining to limitation and sanction. Broadly, I would categorize the judgments in 3 categories. One is dealing with assessment year 15-16 on a standalone basis. The second category is assessment year 13-14, 14-15. Third category is AY 16-17, 17-18. And couple of general observations which are again pertaining to the issue of limitation. Let us start with 15-16 because it's the shortest and probably again has a large number of controversies. Look, the controversy has arisen like this. Let me at least spend 5 to 10 minutes, 5 to 7 minutes on the controversy before we go to Rajiv Bansal per se, because unless we understand our history, we would not be in a position to appreciate what has been laid down. Because The answers are given by the Supreme Court. Maybe we find that those answers are again in turn questions and required to be answered by some court at a later stage. But in order to understand the answers, we must first appreciate what were the questions before the Supreme Court. Reopening is a power which is given to the income tax department so as to revisit the years which have gone by. This is known as remedial action powers. These are the powers which are available with the income tax department if they believe that something which ought to have been taxed during the regular assessment proceedings is left out, and now they want to tax you because they have some information, some recollection. They have some way by which they want to revisit the year which has gone by. Up to 31st March 2021, and that was prevailing since 1989. And if I go back with a slightly grammatical variation, if the law was right from 61, almost in the same category. Up to 31st March 2021, the reopening could have been done within a period of 6 years if AO has reason to believe that some income has escaped assessment because of failure, etc. We are not concerned with that. The two categories of 149, namely larger category up to a period of 6 years, a subcategory where income escaping below 1 lakh rupees up to 4 years, anything above 1 lakh with a recording of the satisfaction, etc. Beyond a period of 4 up to a period of 6 years. This was the existing law. There was again, the scheme was slightly different than the scheme which is introduced at a later stage. Frankly, we will not discuss that because that would digress the situation. After this law for so many years, government thought that we would like to come out with a new law. However, the timing could not have been worse because we all know that COVID, the onset of COVID started happening sometime in March 2020. In March 2020, the whole world faced this unprecedented controversy, and government realized that unless we give extension to the taxpayer as well as taxation authorities, a large number of compliances, large number of limitation will get over. And therefore, government started issuing notifications, ordinances, and thereafter acts so as to extend the limitation, which was working both ways for benefit of SSC as well as for the benefit of the tax officers. So that date was 20th March 2020. The extension started happening, and government extended various compliance dates along with various dates for issuance of notice. For our purposes, we are concerned with issuance of notice under 148. Therefore, we will concentrate purely on that. With that extension happening from time to time, Parliament also decided to change the entire law which was governing the reopening process right from 1st April 2021. So from 1st April 2021, the law now as it stands in the statute book, again that has undergone a change with effect from 1st April 2024. But for our purposes, law existed between 21 to 24 is material. Therefore, again, we will restrict ourselves to that those provisions only. So with effect from 1st April, the limitation was broadly categorized under two heads. One was up to a period of 3 years and up to a period of 10 years. Different criteria were laid down for the purpose of these two categories. This was in juxtaposition to the earlier position of 4 years and 6 years. So 4 became 3 and 6 became 10. Because of this extended limitation and because of the change in the scheme of the Act, the large number of controversies started happening because government, while giving benefit under TOLA, also extended the law from time to time up to a period of 31st March 2021. No controversies up to 31st March 2021. From 31st March 2021 to 30th June 2021, the whole controversy started because government, by virtue of TOLA is an empowering legislation which gives a power of extension to the authorities. And by exercising that delegated power, the authority said that whatever was required to be done on 31st March, namely issuance of notices which were to be issued on 31st March 2021, can be issued up to a period of 30th June 2021. Therefore, that period was extended by a period of almost 91 days. Mind you, the TOLA extension happened from 20th March, 2020, right up to 31st March 21, and thereafter by way of 2 notification up to 30th June 2021. In the meanwhile, as I indicated earlier, Parliament also amended the law with effect from 1st April 2021. And therefore, for this first quarter of financial year 21, namely 1st April 21 to 30th June 21, there were 2 laws which were operating in the same field. One was which was extended by exercising power of TOLA, and another was the new law which was amended by the Parliament. And that is how the first round of litigation took place. We all said that, sir, you can't have 2 laws governing the same cause of action, and therefore you decide which one is right. We all SSA submitted that, sir, Parliament is supreme. The executives are working because of Parliament. They are working in a delegated capacity. Therefore, that extension is not valid. It is only the new law which is valid. Courts across the country upheld that particular decision and held that, yes, the notices which were issued by virtue of 2 notification and extension granted under the TOLA under the old act were invalid, and therefore those notices which were issued between 1st April and 30th June, despite there being a new law, under the old law, those notices are invalid. Matter reached to the Supreme Court in the case of Ashish Agrawal. Ashish Agrawal, Supreme Court laid down that there appears to be some error on the part of the assessing authority. They did not realize the enormity of the problem. There are 90,000 cases, 67,000 crore worth of revenue, which is at stake. And therefore, we would like to give one more opportunity to the revenue authorities. And therefore, they invoked Article 142. And they said that we will set right the thing. We will convert those old notices into the notices under section 148, capital A, small b, that is at a show cause notice stage. Once Supreme Court upheld that, there was no question of then anyone challenging that. And therefore, Supreme Court said that we will direct the authorities to treat the old notices as a show cause notice under the new scheme, under the Parliament's laid down law. Therefore, the SSCs were held as right in contending that the law which is laid down by the Parliament is the correct law. However, they did not cause the notices. They say that we will consider these notices as a show cause notice under the new scheme. And that is how the second round started, which is ultimately answered by Rajiv Bansal. In the second round, the arguments were broadly on the ground of limitation that, sir, this is a notice which is a show cause notice. Once it is treated as a show cause notice, ultimately it must result into the final notices. By the time the final notices are issued, the time permissible for the purpose of issuance of such notices have already expired, and therefore you do not have the jurisdiction. For 13-14, under the old regime, 6 years time is permissible. Therefore, once we go with that 6 years limitation period, 13-14, the limitation would expire 31st March 20. By virtue of TOLA, it got extended up to 31st March 21. For 14-15, it was 31st March 21. And therefore, both these limitations expired on 31st March 2021. Even the show cause notice which is issued is beyond a period of 6 years thereafter. Much less the final notices under 148 came to be issued at a much later stage, sometime in July, August 2022. Therefore, the whole issue was barred by limitation insofar as 13-14 and 14-15 are concerned. Again, high courts across the country accepted this argument of the SSCs and decided the issue in favor. Again, the government approached the Supreme Court. The lead judgment was Rajiv Bansal's judgment delivered by Allahabad High Court, and thereafter followed by Gujarat High Court in the case of Kinara, etc. Again, Supreme Court started hearing the matter, and this is the judgment which is now delivered on the basic factual premise which I just narrated. The first interesting issue is, let us now look at the judgment per se. Let us start with 13, 14, 14, 15, because I've already spent some time on 13, 14, 14, 15. Therefore, let us start with 13, 14, 14, 15. What is the law which is laid down by the Supreme Court on 13, 14, 14, 15? The predominant argument was that, sir, 13, 14, 14, 15, the time limit has expired on 31st March 2021. And therefore, you can't extend the law which has expired on 31st March 2021. Once we accept that the law which has ceased to exist, its operation cannot be extended. You can't have TOLA notifications extending the operation of the law which has already been repealed. Under the new law, there is a proviso to 149. The 149 proviso is very interesting. In fact, Supreme Court has explained the proviso in detail. And what has been held by the Supreme Court from paragraphs number 46 to 53 is again worth analyzing. The first proviso to section 149 is basically a savings clause which saves the rights, vested rights of the assessee. We all know that under the old scheme, the outer limit to reopen was 6 years, unless, of course, foreign asset, black money, 16 years, but we are not concerned with that. Therefore, I'll take it that 6 years is the outer limit under the old scheme. Now, under the new scheme, the limitation is 10 years. Therefore, there are 4 additional years which can be reopened immediately upon the reopening. Now, assessees argue, the argument of the assessees were that, sir, if my limitation has already expired by the time the new law came, can I once again be exposed for a larger limitation period of 10 years? Parliament realized this and they have introduced the first proviso. First proviso to 149 says that whenever you are reopening a year, what you need to check is that whether that year could have been reopened under the old limitation period. If the answer is in affirmative, then only you go ahead and reopen. If answer is in negative, you don't reopen those years, because that is the additional protection which is granted to an assessee. The law on the reopening is that you have to pick up the law the day on which reopening notices are being issued. So if I pick up the law, the date on which I am issuing the notices, admittedly there is a new law which is in the statute book. New law says I can go back up to 10 years. Now, the last 4 years, namely year 7, 8, 9 and 10, they have already expired under the old regime, because under the old regime, I could have gone back only up to 6 years. In order to protect the right which has accrued in favor of the assessee, that those years limitation has already expired and we do not want to revive those expired limitation under the new scheme, Parliament introduced the first proviso. Supreme Court has very categorically now held in Rajiv Bansal, and that is my first finding of the judgment, that firstly, the first proviso comes into service every time assessing authority issues a notice. And whenever they are issuing the notice, not only on 1st April 2021, even today also, if they are issuing the notice today, what they need to do is they need to go back to the first proviso. They need to find out that if there is no amendment in the statute book, under the old scheme, am I eligible, am I entitled to issue this notice as per the limitations prescribed under the old scheme? And that limitation is only 6 years limitation, because there is a reference to 149 1B of the old act. Therefore, that argument that within 4 years and proviso, etc., those arguments will not be necessary, because that is not what has been appreciated by the Supreme Court. Therefore, today, if I want to issue the notice, what I need to do is I need to go to the proviso. I'll check whether the 6 years limitation is available today as per the old section. If that limitation is available, I am entitled to issue the notice under the new scheme. If no, then even that notice is not permissible to be issued. Immediately after Rajiv Agrawal, we have a judgment of the Delhi High Court in the case of Pelix Genetics. Delhi High Court has already decided this issue for the purpose of assessment year 17-18, when they held that notice issued after 31st March 2024 is bad in law, because 17-18, the 6 years would have got over on 31st March 24. Any notice which is issued after March 24 is barred by limitation under the old scheme. And therefore, by virtue of this proviso, and Rajiv Bansal has appreciated that aspect very well, paragraph 46 to 53. Coming back to 1314 and 1415, the argument of the SSs was again on the very same grounds that, sir, if I look at the first proviso, 6 years are over on 31st March 20 and 21 for 1314 and 1415 respectively. And therefore, when the Parliament, by virtue of this amendment, wanted to curtail the reopening power, which are again in sync with the old provision, executive cannot extend that power and say that for first quarter of financial year 21, we will add that additional time to the limitation under the old section. Supreme Court unfortunately did not agree with this argument. Supreme Court said that, sir, TOLA is a specified act. Specified act means it's a fluid act. It says that TOLA refers to the Income Tax Act 1961. It did not say that Income Tax Act of 2021, 2022 or 2023. Therefore, whenever there is a reference to the Income Tax Act, you can't pick up the old book. You have to pick up the current book. And in the current book, if there is a section which is now amended, then whatever limitations which are expiring under the current book, you have to read TOLA as a part of extending factor. So when even in the current proviso, when you read the proviso to 149, you have to read the extension which is granted by TOLA. In other words, Supreme Court held that while you are interpreting the first proviso to 149, while computing the period of 6 years under the old regime, you have to read 6 years as 6 years and 3 months. And that is how Supreme Court said that your argument is not correct when you say that while reading the proviso, you don't read the extension. However, while reading the old law, you can read the extension. Supreme Court, as it's a Supreme Court, therefore, we can't say that we agree or we do not agree. We have no option. This is what the law of the land is under Article 141. We have to all abide by this. So therefore, 13, 14, 14, 15, all the notices are held to be valid. However, there is a silver lining to this. Supreme Court, in the very same judgment, has laid down various other alternative submissions and alternative findings. More particularly, in paragraph 111 and 112, Supreme Court said that we all agree that this is how the limitation is required to be computed. However, it is not an unlimited extension of the limitation. Therefore, while you are given an extended time, that extended time is limited. And therefore, whenever you are doing the proceedings, you have to finish your proceedings within that limited time. If the revenue authorities, they do not finish the job within the specified extended time, then that remaining time is to be counted, and that remaining time, ultimately, if it is vested more than what was extended by the notifications, the notices would be treated as a barred by limitation notification. Supreme Court itself has given one example. Let me share that along with this is that alternate table. It's visible on the screen, right? Okay. I take it that this screen sharing is working. It is visible on the screen, right? The table is visible. Okay. Have a look at this. Supreme Court in paragraph number 111 and 112 has given an example. What the Supreme Court has said is that, sir, limitation is extended from 1st April to 30th June 2021. Therefore, the total addition to the limitation period is 91 days. Kindly look at example number 1. I have picked up 1st April 2021 as the date of issuance of the original notice. So total extension which is granted is for the month of April, May and June. If I sum up this April, May and June, we have total extension of 91 days. So therefore, the limitation would start from the day on which original notice is issued. Supreme Court said that original notice is issued, you start the limitation period. And from that limitation, you count number of days up to 30th June. So if your notice is issued on 1st June, you have 30 days time to pass the final order. If it is issued on 15th May, example number 3, you have 46 days time. If it is issued on 25th June, you have 5 days time to finish the entire job. However, this number of days are to be applied from which date? So in between period, Supreme Court has excluded. What is that period which is excluded? The exclusion period is, Supreme Court said that right up to the date of judgment of Ashish Agrawal, everything is required to be excluded. Good enough. So therefore, we will go right from the day, that is in the example given by the Supreme Court, 1st May 2021, we go jump to 4th May 2021. Thereafter, Supreme Court said that you also exclude the number of days which are used for the purpose of issuance of notice under 148A small b, which is a show cause notice. So we remove that, because ultimately what the Supreme Court has done is, Ashish Agrawal said that we will convert all the 148 original notices into the show cause notice under 148AB. Therefore, those show cause notice in the example given by the Supreme Court, 1st May 2021 got converted into the show cause notice 3rd June 2022. So we remove in between period. We start the meter on 3rd June 2021. Then Supreme Court said that by virtue of 5th proviso to 149, whatever time that is given to the SSC for filing the response is also required to be excluded. Therefore, the 5th proviso, the time given to the SSC and any time which is stayed by the court of law is required to be excluded. For the purpose of understanding this, we say that it is the replies are filed, notices were issued on 3rd June, replies are filed on 18th June. Therefore, time taken up to 18th June is also removed from this example. After 18th June, revenue has 61 days time, because 61 days time is counted from 1st May till 30th June 2021. So we add 61 days to 18th June 2022. We get the outer limit of 18th August 2022. If the notices are issued within 18th August, then it is within limitation. For the purpose of understanding this, I have taken the notices have been issued on 12th August 2022. Both D order, clause D order, as well as 148 notices, both were issued on the same day, because most of the cases it is issued on the same day, or there is a difference of around 1 day between the two. Therefore, 12th August. So therefore, this is within limitation. The example which I have, which is picked up by the Supreme Court. However, in the second, third, and fourth example, you would find that all these notices are beyond time. I have kept all these dates within on the same parameter. If I pick up example number 3, 15th May 2021, then from counting from 15th May 2021 to 30th June 2021, I have 46 days time. So limitation would start on 3rd June by virtue of 5th proviso. The period which is given to SSC to response, to file the response, is 18th June 2022. That period is required to be excluded. After 18th June, the limitation starts, and I can get, the revenue authorities can get additional 46 days to pass 148 AD order and issue notice under 148. So that ought to have been done within a period of 3rd August 2022. However, the final notice is issued on 12th August 2022. Therefore, it is barred by limitation. So what is the summary of this table? The summary of this table is that by and large, my experience is that sometime in the month of May 2022, immediately after Ashish Agrawal, Revenue came out with a circular on 11th May 2022. There they laid down various modus. After that circular, people started receiving notices under 148 AB, that is the show cause notices, along with material, etc., which is supplied by the Supreme, as per the direction of the Supreme Court. That material, etc., I'll briefly mention at the end of my speech that what is the significance of that. and whether to go for it or not to go for it. However, in the month of May 2022, later half of May 2022, people started receiving the notices under 148 AB. Usually 2 weeks time is given. Many a times SSAs ask for extension. If there is an extension, that extension again will have to be kept outside the limitation period. However, the experience is that by and large SSAs complied in the month of June itself, somewhere by the middle of the June. All SSAs by and large filed the responses sometime in the middle of June up to 20th or 25th of June. Therefore, the authorities ought to have passed the order immediately. However, they have taken almost the entire month of July and the month of August up to some extent. And thereafter, they started issuing the notices under 148 AD as well as 148. So, mota mote, if at all, your period or your notices are issued after 15th May 2021, probably your notice would become time barred because revenue authorities certainly took more than 45 days to process your response. And that is the period which is not excluded from any limitation computation. Therefore, if your notices are issued after 15th May, again, it depends on the case-to-case basis. I'm just trying to generalize it so that you can examine your facts. But after 15th May, probably you will get out on the ground of limitation. That would take me to 1516. 1516 is an interesting story. You would find that for 1516, again, I'm stopping this for a moment. And I'm sharing Rajiv Bansal. Kindly mark paragraph F, which is available on the screen. This is the concession which was given by the Council for the Revenue. That revenue concedes that for assessment year 1516, all notices issued on or after 1st April 21 will have to be dropped as they do not fall for completion during the period prescribed under TOLA. Why concession? It was for the very simple reason that what TOLA extended was what was expiring or where the limitation was getting over during the period up to 31st March 21 and thereafter from 31st March 21 to 30th June 2021. For AY 1516, the 6 years will get over on 31st March 2022. Therefore, there was nothing which was getting expired between 20th March 2020 and 30th June 2021. Therefore, TOLA has no application whatsoever for AY 1516 at all. Once TOLA does not apply, Supreme Court at repeated places said that what is extended is what was expiring by virtue of TOLA. By virtue of the limitation period, what is extended by TOLA is what was expiring. Because this was not expiring, there is no question of applying or extending anything which is otherwise expiring. Kindly see even paragraph number 54. Supreme Court, when they summarize the position, mark this. Earlier they mentioned 1516. However, in the extension is in the following manner. 1, 13, 14, 14, 15, 6 years. 31st March 21. 16, 17, 17, 18, 3 years on so and so. And therefore, 1516 was deliberately again kept out. And therefore, the argument was substantiated. Unfortunately for us, despite this concession in the final summary of the judgment, we do not find any mention of 1516. Supreme Court ought to have clarified that because of this concession, all the matters of 1516 filed by the revenue are hereby dismissed. Unfortunately, that has not been done. Neither there is a finding to the effect that because 1516 TOLA was not applicable, there was no question of any extension, and therefore also 1516 is required to be kept outside this controversy. There is no such finding. And therefore the question would be that whether 1516, if at all covered by TOLA, answer is no. 1516 was not at all covered by TOLA. The argument on the part of the revenue today is that, sir, there was an order of Ashish Agrawal. Ashish Agrawal said that whatever notices that were issued between 1st April to 30th June 21, they all got revived by converting the old notices into 148 AB notices. 15-16 was one of the years in Ashish Agrawal. Because 15-16 was also one of the years in Ashish Agrawal, it also got converted into 148 AB notice. And therefore, automatically it got extension. It is now revived. And 15-16 is something which is permissible because the law is silent on this. Because at some stage in paragraph 52, later half is there that so-and-so also considered on behalf of the revenue that all notices issued under the new regime by invoking the 6 years limit under so-and-so of the old regime will be able to be dropped if the income chargeable to tax, which has escape assessment, is less than 50 lakhs. So now they argue that, sir, 15-16, if the income is more than 50 lakhs, it survives. Now, that is something which I personally believe that hitting below the belt, because having considered, now nobody can turn around and say that, sir, that concession was only because it was an unqualified concession. Mind you, these are the notes which were given in writing by the respective authorities to the Supreme Court, and Supreme Court has reproduced verbatim as it is. If there is no qualification in the concession, then there is no question of now saying that, sir, it is only 50 lakhs. That said, today, where do we stand? Do we say that 15-16 is, my respectful submission is that if we read paragraphs 62 to 67, 71, 72, and more particularly 68 of the judgment in question, the conclusion is inevitable. And that conclusion is that what was extended by Ashish in conjecture with Tola was something which was expiring during this period. 15-16, admittedly, nothing was expiring during this period. If that be so, can we have an extension of something which is still alive? Extension is required for something which has expired. And that is the common sense. And therefore, my humble view is that 15-16 has to go. There is one more interesting way of looking at 15-16. And that even otherwise, 15-16 will go. Let me substantiate that by once again sharing something which is a 15-16 table. Look, this is a 15-16 table. 15-16, all these notices, again, I've kept the same dates, etc. 15-16, the notices were issued between 1st April 21 and 30th June 2021. Admittedly, 15-16, the last date for issuance of notice is 31st March 2022. There is no extension for 15-16 because Tola did not apply to 15-16 at all. There was nothing which was expiring between that COVID period, and therefore Tola did not have any application. So it was all expiring on March 22, 31st March 22. However, Supreme Court in paragraph 94 of this judgment said that we will extend the limitation generally because issue was at large before the Supreme Court in the case of Ashish Agrawal. So we reach up to May 22, 4th May 2022. Then comes the notice, which is issued under 148 AB. Again, we go with the 5th proviso, which says that whenever you issue notice under clause B, the time again stops. So right from Ashish Agrawal to 3rd June, when the actual notices were issued. This is just for the purpose of understanding. In your case, notice might have been issued on some other date. So that calculation you will have to do. Please don't ask me question by mentioning the date and ask me that, sir, whether this is expired or not. That you do. I'll just explain you the formula. So for the purpose of understanding this, I have given the date as 148 AB notice, 3rd June 2022. I am ready to even exclude period up to 3rd June 2022. That period go out. My reply is filed on 18th June. Let reply period also go out by virtue of 5th proviso. However, what is the extension? Look, in the 13, 14, 14, 15, I pointed out that total 91 days extension was granted. Out of that, whenever the notice was issued, you'll have to count the remaining days, and that is the extension which you have to add after your response, so as to give revenue authorities time to pass the necessary order. In case of 15-16, there is no such extension. Therefore, the sixth proviso to 149 says that whenever less than 7 days are left with the assessing authority for the purpose of passing the order under clause D and issuing the final notice under 148, if it is less than 7 days, you have to at least give minimum 7 days to the revenue authorities. Yes, we go with the sixth proviso, add 7 days. Once you file the response, in response to clause D notice, add 7 days. The moment 7 days are added, the limitation is over. So even 15-16 will go out on the limitation. Here again, the analysis of the Supreme Court in paragraph number 46 to 53 with respect to first proviso will be helpful to you, because Supreme Court laid down that actually whenever the notices are issued, 148 notice is issued, you have to look at the limitation and find out whether under the old section 149(1)(b) the notice could have been issued or not. That period is 6 years. Therefore, 31st March 22, any notice issued thereafter, you have 7 days time. Whenever your last response in response to 148AB is filed, you have 7 days time. Revenue authorities, if they do not pass it within the 7 days time, even otherwise, 15-16 also limitation expires. That would take me to the last limb, 16-17 and 17-18. Look, 16-17, 17-18, the controversy is slightly different. 16-17, 17-18, the controversy is with respect to the sanction of the specified authority. Supreme Court has observed at more than one places that sanction is a precondition. Without sanction, there is no question of issuance of notice. Supreme Court said that there are 4 sanctions which are required. 148 capital A, small b, small d, and actual 148 notice. However, Supreme Court said that small a and small b sanctions have been done away with by Ashish Agrawal. Clause D and 148 sanctions are still remaining, and therefore they are required to be obtained before the notice can be issued. The second important thing is, under 151, there is no question of any limitation. Because unlike 149, where the limitation is there, under the then existing 151, there was no question of any limitation, because there was nothing which was getting expired. There is no outer limit, inner limit, nothing. Only limitation which is embedded into 151 is that if it is within a period of 3 years, sanction of a lower authority. If it is beyond a period of 3 years, more than 3 years, sanction of a higher authority. This is the only precondition which is there. Nothing of the sort which is there in 149, that this is the outer limit beyond which nothing can be obtained. Therefore, there is no question of any limitation. The only thing is whether it is falling within period of 3 years or beyond a period of 3 years. Supreme Court has explained this in paragraphs 77, 78, 81, wherein they have categorized that by giving an example, that whenever the sanction was to be obtained from 20th March 2020 up to 31st March 2021, the same is extended up to a period of 30th June 2021. In other words, for 17-18, if the sanction was to be obtained within a period of 3 years, if the reopening is happening within a period of 3 years, then of a lower authority, and that has to be done before 31st March 21. However, if that is not done, then up to 30th June, if they take the sanction, then even that lower authority can grant the sanction. Supreme Court did not say anything as regards what would happen to the sanction which are to be obtained at the time of issuance of notice, in our case in 2022, July, August 2022. In other words, the Supreme Court is very clear in its mind that it's only the period of 3 years which gets extended. The moment that 30th June 2021 limitation is over, there is no extension, because what do you extend? There is nothing there to extend. It is not limitation that is getting expired. It is only the category under which you are following. If you are falling under first category of a lower authority, second category of a higher authority, Supreme Court said that for lower authority, we extend 3 months time. There is no extension of for higher authority. As and when you issue the notice, you obtain the signature or sanction of a higher authority. So in all those cases of 1617 and 1718, where the authorities have taken the sanction of a lower authority by falling it within 151 small Roman 1, all those notices are without any sanction. Supreme Court has held that any notice which is without proper sanction is all bad in law, and therefore that is required to be excluded. There is one more interesting facet to 151, and that interesting facet is under, if you recollect, under the old 13, 14, 14, 15, we pointed out that the limitation is to be counted up to Ashish Agrawal, that is 4th May 22. From 4th May 22, you apply the 5th proviso, namely 148AB notice, etc. However, that is also not available for 151. Look at this. This is 151. Kindly see the proviso, which was added with effect from 1st April 2023. Provided that the period of 3 years for the purpose of clause 1 shall be computed after taking into account the period of limitation as excluded by the 3rd, 4th, 5th provisos or extended by the 6th proviso to subsection 1 of 149. So 5th proviso is that exclusion of notice and response period, and 6th is minimum 7 days. This was not applicable to 151 at all. This proviso made this exclusions while counting the limitation applicable with effect from 1st April 2023. The words where no principal commissioner omitted with effect from so and so, and 79B says that inserted by Finance Act 23, 1st April 2023. Therefore, even these provisos which we are using for the purpose of 13, 14, 14, 15 cannot come to the rescue of the department when we are finding out under which authority they have to take the sanction under 151. And therefore, the moment Ashish Agrawal is delivered on 4th May, there was nothing which can be, for the purpose of limitation, can be excluded, because these provisos are not applicable at all. So for 151, our computation is on a much stronger footing. The moment Ashish Agrawal is delivered, your limitation starts, and any sanction after that necessarily has to be that of the principal chief commissioner or principal director general or chief commissioner, etc. Mind you, here also there is an amendment 79A, and that also is something which is different. And again, that is with effect from 1st April 23. Therefore, when you are actually analyzing the paper, pick up the act of the relevant year and then find out whether it is by the proper authority or no. Therefore, all those cases, and mind you, almost all the cases of 16, 17, 17, 18, sanction is by the lower authority. And that is also now decided by the Supreme Court in the favor of the SSC. That said, exactly my 45 minutes are over. Only one additional point which I want to make out, and that point is Supreme Court at some places or more than one places has observed that whenever Ashish Agrawal was implemented, Ashish Agrawal came with two things. One, you issue the show cause notice under 148AB and also supply the material which is relied upon for the purpose of drafting that show cause notice. And therefore, unless that material is given, the notice will not be treated as a valid notice. Many SSCs have raised the questions, have also demanded that, sir, supply us the material, otherwise we will not respond, or your response is your show cause notice is not tenable because you have not supplied us the material. It's a trap. Don't fall for that. Because Supreme Court in the next paragraph has held that unless that material is supplied, there will not be any show cause. Unless there is a show cause, your limitation will never get over, because limitation would start running from the day of show cause till you file the response, and thereafter you have to exclude those number of days. Therefore, if any notices are issued, if you have written the letter, don't press it. Don't demand any material now, because otherwise, even if your case is within limitation, and if you believe that notices are issued in the first week of April 21 itself, probably you can always demand this material. However, if your notice is issued sometime in the later half of May 21 and June 21, then don't fall for this trap, because the moment you demand material, your limitation will again get extended, and it is always better to get out on the limitation aspect rather than fighting it on merits, because ultimately merits will take you again back to the Supreme Court. That said, friends, my personal 2 cents, my view is that Supreme Court has opened again a third round of litigation, whether we like it or no, because these are the issues which are not going to be accepted by the revenue authorities. They are again going to fight tooth and nail. On one hand, government is seriously working hard, and we really appreciate that, by increasing the limit of the revenue filing, monetary limits for filing of the revenue appeals. They are coming out with VSV schemes. The least that they can do now is make all these SSCs who are suffering from Rajiv Bansal's case, their petitions are pending at various stages. If the government can amend VSV, and they also include the REIT petitioners, because in the definition of appellant, REIT is mentioned. However, in the FAQs in earlier scheme as well as in this scheme, probably REIT are not included. So if government can include REITs also, probably large number of SSCs would now like to buy peace of mind, because they are all tired. First round, second round, third round, and so on and so forth. And this controversy, the way it looks to me today, it's not going to die down very soon. Probably we'll see further rounds in times to come. Therefore, the only final take on my part is that Supreme Court has not solved any problem. The problem is now multifarious, multifold, and we'll have to be ready for next round of litigation. Only time will tell us that whether our interpretation is correct or whether revenue's interpretation is correct. With this, friends, I once again thank you all for giving me this platform to share some of my thoughts. Over to you, Pragnesh bhai, question answers.
Yeah. Thank you very much, Tushar bhai. It was wonderful, and the homework that you have done was of great help to every person who have been here. I request all the participants to give your question answers in the Q&A box. Till the question answers come up, first thought from the deliberation by our respected Tushar Hemani. I request Mitesh Modi to give his first thoughts on what was deliberated from the last 1 hour. Mitesh bhai.
Thank you, Tushar bhai. You rightly said that one more round is going to be in future, more litigation and litigation. I appreciate your concern that the department should include the REITs in the VSVT so that the taxpayers in litigation waiting for the solution since so many years, they can get the justice and peace of mind. But my point about the sanction 151, you have analyzed that there is no, you read the proviso, first proviso below section 151. So extension period is not available in so far as sanction under section 151 is required. While under section 148A and 148 and 149, we have to read with the extended period. If the extended period is not expired, time limit is not expired. I request you to analyze in deep within 2 minutes, because 151 sanction is the precondition, is a settled proposition of law, because the sanction from the higher authority, now they have categorized in clause A and B. And in many of the cases, now we can challenge the sanction is not proper as per the law or without jurisdiction, and the SSC can get his case in his favor on this ground, legal ground also. So it is very much beneficial if we analyze deeply the sanction as provided under section 151. This is very important aspect in my opinion. So I request you at least for 2 minutes, 151, how it is helpful for the taxpayers. Now after the Rajiv Bansal, when we proceed in the assessment proceedings, we will continue in the reassessment proceedings. Can we raise this legal issue during the reassessment proceeding itself, or at the later stage before the appellate forum? This is my precise query.
Look, if idea is that, kindly have a look at the scheme of the act. The act is sanction for issuance of notice. Supreme Court said that this is a precondition. So unless that sanction is obtained, and that too by the right authority, that there is no question of issuance of 148 notice. There are 2 categories, small Roman 1 and small Roman 2. Kindly read the proviso carefully. It only refers to clause 1. Therefore, there is an extension of only 3 years period, because for category 2, there is no time limit which is prescribed. So there is no question of any extension for part 2. So part 2 is one where at any time, 151 does not have any outer limit. 149 has, 147 has, 148 has. However, 151 does not have any outer limit. Therefore, the proviso also wherein this extension of time is only for category 1. When you are counting the period of 3 years, you have to remove this 2 periods. One is the notice, that is 148 AB notice period, and our response time which is taken. That is one exclusion. And second is, if at all less than 7 days, you add it to 7 days. Other than that, third and fourth proviso are all relating to search related things, not necessary for our purposes for this controversy. That said, what is the best time to take this defense? Look, there are 2 ways in which 151 will have to be analyzed by the courts eventually. One is the basic sanction. The sanction itself, whether it is obtained, rightly obtained. These 2 questions go to the very root of the matter. They are jurisdictional questions. And if at all you find that either they are not obtained or obtained from a wrong authority, then it is better to challenge the notice itself at this stage and get it quashed by the respective constitutional court. However, if you find that no, sanctions are obtained properly, but then sanctions are obtained probably not by application of mind, because when you look at the sanction, you find that it's a one-line order that I agree with AO, these, that. And if you really want to challenge that particular subjective satisfaction of the sanctioning authority, then the better forum is the appellate forum rather than going to the court, because court would not go into sufficiency. Many a times courts have gone into the sufficiency if you have enough material, but more often than not, courts would say that, sir, you raise that objection before the lower authorities and then come via the regular route. Therefore, if you want to challenge the qualitative aspect of sanction, namely the subjective satisfaction, it is better to go before the appellate authority. If you want to challenge the jurisdictional fact, then probably it is better to challenge it before the appropriate constitutional court.
Yeah, thank you very much. And very rightly questioned, Mitesh Bhai, because this 151 section holds a very core to this thing. Now, we have very senior chartered accountant here, Kishore Giwala. Kishore Giwala, your first thoughts and any queries to Tushar Hemani.
Sir, hello. Sir, congrats for excellent deliberation and very discussion in a very lucid manner on a very controversial issue. Sir, I have a query that there has been a judgment of the Supreme Court in the Corona period, suo motu judgment, extending the various time limits from time to time. And the last judgment, the time limit was extended up to say 20th February 2022 or 31st March 2022. Can that have any relevance in the issue?
Yes, there are after 29th February 22 plus 90 days for the purpose of complying, because those limitations Supreme Court granted further 90 days. Look, that extension of limitation insofar as this controversy is concerned is not very germane for the issue, for the simple reason that here is a case where all the happenings are after 4th May 2022. In any case, in paragraph 94 of the Supreme Court judgment, they have excluded time up to 4th May 2022, even otherwise. So therefore, whether by virtue of Ashish Agrawal or by virtue of that judgment, common causes judgment, wherein this extension is there is no difference, because ultimately that period is excluded. So therefore, probably we will not have much of a difference when it comes to that Corona period judgment.
Yeah, thank you very much, Tushar Bhai. Now, we have somebody very close to you, that's from Ahmedabad. We have from the Income Tax Bar Association, Sridhar Shah. I request Sridhar Shah to please unmute. Sridhar ji.
Hello. Hello, audible?
Yes, it is.
Yeah, audible, Sridhar.
So it is always pleasure to listen to sir, and you keep listening the way sir explains the details. And the beauty of the Act of 1961 is that It is enriched with so many legal judgments from various courts and authorities. And when Nirmala ma'am said that the new act will replace, the first fear was, what about the settled positions? But today I came to know that there are few positions which can get actually unsettled with the judgment of Supreme Court too. Sir has given fair idea about all the provisions and the view that VSV scheme should include such cases so that assessees can get actual benefit of VSV scheme. That should definitely go to the finance ministry. Thank you, sir, for such a nice session. And I thank all the participants and especially from Income Tax Bar Association too, that you joined the webinar. Thank you.
So, Sridharji, are you going to say something that is the best time to be an advocate in the Supreme Court or the High Court or the worst time? Will leave that answer?
Tushar sir can highlight it. I would always become, see, if option is given, I would always like to be part of SGCCI as a businessman rather than going to be a CA and advocate.
That's great. You get your answer right from Kaun Banega Crorepati, you're the right choice. From the All Gujarat Federation of Tax Consultants, we have Mrudang Vakil. If Mrudang ji is there, are you there, Mrudang ji? MRUDANG? Jo? Yeah, Bhavin Atul. Bhavin ji is there? Yeah, Bhavin Patel, yeah. Can you please unmute? Yeah, please unmute yourself. Bhavin ji, please, and switch on your mic, your audio or video also, so that we can always have the opportunity of seeing you. Bhavin ji. Your video is off.
Video is my off.
Okay, carry on, not an issue.
Can I audible?
Very much audible.
Yeah. Thank you, sir. I, Bhavin Patel, Secretary, on behalf of Central Gujarat Chamber of Tax Consultants, would like to extend my warm greetings to all of associations. I express my heartfelt gratitude to our esteemed speaker, Senior Advocate Tushar Himani sir, who will share his expert insights on recent Supreme Court decision of Union of India versus Rajiv Bansal. His nicely delivered and significant wording will greatly enhance our understanding of its implications. The throughout examination he provides of this case highly valuable in his realm and administrative and service law. I also wish to extend my sincere compliments to all the organization teams of today's virtual session, which is the collaborative efforts of Central Gujarat Chamber of Commerce and Industries, ICAI Surat, ITAT Bar Association Surat, SGITBA, All Gujarat Federation of Tax Consultants, and ITBA. A special thank to Anil Shah for his coordination and for keeping up every aspect of this session. I would also like to acknowledge Anup Jariwala sir, Viraj Rudala sir, obvious Pragnesh Jagasets, Deepak Sakarwala, Kishore Ghiwala sir, Tanish Modi, and entire team of Sagan Gujarat Commerce and Industries. I dedicated to selecting such an important subject and conducting this event so effectively is truly commendable. Thank you, sir, and hope we will be jointly do seminar in future also.
Yeah. Thank you very much. It was wonderful from Bhavinji. And to sum up all, we have the workhouse and the person who centralizes everything, who coordinates everything, Dipesh Shakwala. The wonderful personality. A few words from Dipesh Shakwala, then vote of thanks and some questions from.
Sorry to interrupt. Mrudang Vakil is there from AGFTC, but he is not panelist. So if you can make him.
Yeah. He'll be take till then Dipesh Shakwala.
Yeah. Okay. So he is into attendees.
Hello.
Thank you.
Hello.
Thank you to sir for wonderful speech and wonderful guidance to the audience. And thanks to all associations. Thank you very much, sir.
Pradhanji, are you online?
Yes, I am online.
Yeah, please. Your deliberation on a wonderful deliberation by our very beloved and learned Tushar Hemani.
Am I audible?
100% audible. But
Sir,
not
when
visible.
Tushar sir is delivering the lecture, how can no one be there, sir? I am always there. Friends, on behalf of the AGFTC, my deep sense of gratitude to Senior Advocate Shri Tushar Hemani for delivering his speech. Friends, so far as income tax is concerned, reopening of assessment is the hot cake since many years, but more particularly since last 3-4 years. Many swings turn the table of reopening of assessment. And latest one is the decision delivered by the Honorable Supreme Court in the case of Union of India versus Rajiv Bansal. Friends, so far as REITs are concerned, challenging the validity of notice of reopening of assessment, to my mind, I think highest ever REIT are filed from the state of Gujarat. And that too, to my mind, it is from the office of the expert. So for the reanalyzing the same, no other person is the better than Mr. Tushar Hemani. I once again are deeply thankful to Tushar for sparing his valuable time to explain each and every possible aspect of the subject. Thank you very much, Tushar. I extend my deep sense of gratitude to all co-organizers joining the hands to organize such a burning and critical topic on the income tax and reopening of assessment. I also thankful to Anil Bhai Shah for taking keen interest to organizing such an event. And lastly, all the participants who joined across the country to listen one and only Mr. Tushar Hemani in such a large number. I once again thank you very much, Tushar for your sparing valuable time. Thank you.
Thank you so much. Now, just to acknowledge that we have all the way from Canada, the president of Southern Gujarat Income Tax Bar Association, Kulin Pathak, who has joined all the way from Canada. That's a wonderful thing. Till we can get him some questions from Viresh Rudalan.
તુષારભાઈ કેમ છો?
કેમ છો?
થોડાક મોડા પરથી થકાન છે પણ સરસ્વતી માતાનો બ્રાઇટનેસ પણ છે.
થેન્ક યુ સર.
આટલું સરસ ધ વે ઇન વિચ યુ હેવ
ડિપાર્ટમેન્ટે થકાવી દીધા છે.
નહીં પણ સાહેબ થકાન લાગે છે પણ છતાં તમે યુ આર એવરગ્રીન. છો તમને સુપ્રીમ કોર્ટમાં સાંભળતા જોયા છે સર. નાઉ સર માય ક્વેશ્ચન ઇઝ કે એવાય 13-14 કોસ્ટ થઈ ગયા 14-15 ધ સેમ ફેટ. હવે એમાં ડિપાર્ટમેન્ટ આગળ ગયું ન હોય, if the department has not preferred appeal before the Supreme Court, તો આ જજમેન્ટનું કેવી રીતે આપણે લાગશે સાહેબ?
ડિપાર્ટમેન્ટે એક્સેપ્ટ કરી દીધું હોય તમારું જજમેન્ટ અને ડિપાર્ટમેન્ટ જો આગળ ના ગયું હોય તો અનલેસ જે જજમેન્ટ તમારી ફેવરમાં છે એ કોઈ ઓથોરિટી દ્વારા અપટર્ન ના થાય ત્યાં સુધી એ જજમેન્ટ તમારા કેસ માટે બાઇન્ડિંગ થાય, એટલે તમારા કેસમાં તમારા ફાયદામાં રહેશે. ડિપાર્ટમેન્ટ એમાં કદાચ બિલેટેડ એસએલપી કરી અને જજમેન્ટ અપટર્ન કરાવે તો જ થાય, અથવા તો તે લોકો પોતા આ કેસમાં રિવ્યુ ફાઇલ કરશે હાઈકોર્ટની સામે અને રિવાઇવ કરશે મેટરને. બેમાંથી એક પણ વસ્તુ જો ના કરે તો ઇટ બીકમ્સ ફાઇનલ ઇન યોર કેસ.
એટલે આમાં ભૂલચૂક થઈ ગઈ લાગે છે ઘણા કેસમાં, તો એમાં પછી ડિલેટેડ પછી એ લોકો જઈ શકે સુપ્રીમ કોર્ટમાં ડિલેટ કોન્ડન કરી.
સુપ્રીમ કોર્ટમાં તો કોઈ 2-4 વર્ષનો ડિલે સામે કોઈ જોતું પણ નથી, એટલે તો ગમે ત્યારે કવડ કહીને પાછી આવશે, જીવતું થશે.
સર મારો બીજો ક્વેશ્ચન એ છે કે જે હવે 13-14-15 તો આપણે એક એનું એ થઈ ગયું છે કે ભાઈ એનો ચુકાદો લગભગ કન્ફર્મ આવી ગયો છે કે હવે આપણી પાસે કોઈ રેમેડી છે નહીં. પણ ઇન ધેટ કેસ હવે શું થાય કે પછી જે આપણે બીજા સાહેબ આપણે 2nd, 3rd, 4th ગ્રાઉન્ડ્સ લીધેલા છે, that will survive or we have to file again the petition?
નહીં, એટલે અત્યારે તમારા કેસમાં સુપ્રીમ કોર્ટમાં આપણે ગયા છીએ 13, 14, 15માં. એની વાત કરો છો કે જે નથી ગયા એની વાત કરો છો?
નહીં, હવે નથી ગયા એની વાત કરીએ છીએ સાહેબ. અને એમાં એટલે કે આ આગળ સુપ્રીમ કોર્ટમાં ડિપાર્ટમેન્ટ ગયું છે ને, આપ તો હવે 13-14-15 તો આપણે ફાઇનલ થઈ ગયું.
બરાબર.
પણ હવે બાકીના જે ઇશ્યુઝ છે સાહેબ, ધારો કે પર્સન ઇઝ ડેડ
હા
અને એના માટે જ્યારે આપણે સાહેબ બધા એઝ યુઝ્યુઅલ આપ સાહેબ લો છો બધા ઓલ્ટરનેટિવ
Right.
ગ્રાઉન્ડ્સ,
રાઈટ.
તો હવે ઓટોમેટિકલી સર્વાઈવ થશે પિટિશન કે પછી we have
નહીં
to
અત્યારે
again fight?
શું કે ગુજરાત હાઈકોર્ટમાં લેટ્સ સે પિટિશન ફાઇલ કરી આપણે અને એના અંદર આપણે લિમિટેશન અને સાથે બીજા 3 ગ્રાઉન્ડ્સ લીધા. ગુજરાત હાઈકોર્ટે માત્ર લિમિટેશનના ગ્રાઉન્ડ ઉપર આપણી પિટિશન અલાઉ કરી દીધી. બીજા ગ્રાઉન્ડ્સ
Correct, sir.
ડિસમિસ બી ના કર્યા, અલાઉ બી ના કર્યા, ફાઇન્ડિંગ જ નથી એના ઉપર, એડ્યુડિકેશન ના કર્યું. સુપ્રીમ કોર્ટમાં ગયા, સુપ્રીમ કોર્ટમાં ડિપાર્ટમેન્ટની મેટર અલાઉ થઈ. સુપ્રીમ કોર્ટે ડાયરેક્શન એસેસિંગ ઓફિસરને એ આપી છે કે આ ઓર્ડર ગિવિંગ ઇફેક્ટ સુપ્રીમ કોર્ટનો ઓર્ડર કરો ત્યારે યુ હેવ ટુ પાસ ડિસ્પોઝિંગ ઓફ ધ ઓબ્જેક્શન્સ ઓફ ધ એસએસસી ઇન અ ડિટેલ મેનર. એ જે ઓર્ડર છે એ પ્રમાણે હવે ડિપાર્ટમેન્ટે એ ઓર્ડર પ્રમાણે ડિસ્પોઝલ કરશે. વન્સ વી રિસીવ ધેટ ઓર્ડર દેન વીલ હેવ ટુ અગેન ફ્રેશ કોઝ ઓફ એક્શન હશે આપણી પાસે, ત્યારે નક્કી કરીશું કે આપણે જવું કે ના જવું કે એપેલેટ રૂટથી આગળ જવું.
સર એક ક્વેશ્ચન એવો છે કે 15-16 માટે જે એઝ યુ ટોક ટુ અસ કે ભાઈ 15-16 માં જે આપણે પાસે હવે ગ્રાઉન્ડ્સ રહ્યું તે મોર દેન 50 lakhsમાં જ વી આર નાઉ હેવ ટુ ફાઇટ વિથ ધ ડિપાર્ટમેન્ટ. 50 lakhsની જો અબાવ હશે તો બિલો હોય તો તે પ્રમાણે પછી આપણો કોઝ ઓફ એક્શન રહેશે 15-16 માટે હજુ પણ.
15-16 ના મેટરો તો કોઈ આમ બી આપણા ગુજરાતના કોઈ સુપ્રીમમાં ગયા નથી, કારણ કે ગુજરાતની બધી મેટરો ગુજરાતમાં જ પેન્ડિંગ છે. એ બધા બોમ્બેના એસએસસીઝ હતા, એટલે અહીંના ગુજરાતના તો 15-16 વાળા કોઈ પણ કેસ સુપ્રીમ કોર્ટમાં ગયા નથી. હવે બેઝડ ઓન ધીસ એ લોકો ગુજરાત હાઈકોર્ટ સામે શું પોઝિશન લેશે, ઓર જેમના મેટર્સની અંદર 15-16 નું ગ્રાઉન્ડ છે એ નીચે આપણે કોઈ રીટ ના કરી હોય ને અત્યારે એસેસમેન્ટ ઓર્ડર થઈ ગયો હોય, અપીલમાં પેન્ડિંગ હોય ને ત્યાં ગ્રાઉન્ડ લીધેલું હોય, તો સુપ્રીમ કોર્ટના બેઝિસ ઉપર આપણે ત્યાં આર્ગ્યુ કરી શકાય કે ભાઈ આ વસ્તુ છે એ ત્યાં તમારા કાઉન્સિલે પ્રેસ નથી કરી એટલે અમારી ફેવરમાં કરો. અલ્ટિમેટલી એ નક્કી કરશે, ગુજરાત હાઈકોર્ટમાં પેન્ડિંગ છે બધી મેટરો.
ઓકે, અને સર લાસ્ટ ક્વેશ્ચન એ છે મારો કે આપે જે કહ્યું કે ભાઈ જૂન બહુ જ લેટ જૂન 21 માં એ લોકોએ ઇસ્યુ કરી હોય તો ધેટ મીન્સ એકોર્ડિંગ ટુ યુ એ લોકો પાસે બહુ જ ઓછો સમય રહી છે, નોટ 91 days, ઇવન હાર્ડલી 7 days કે 15 days.
એટલે જ્યાં 7 થી નીચો હોય ત્યાં 7 થઈ જાય અને 7 થી વધારે હોય તો એટલો એકચ્યુઅલ સમય.
ઓકે સર, થેન્ક યુ સો મચ સર.
Thank you. If we have Kulin bhai, Kulin Pathak on, is it audible, Kulin bhai?
Yes, yes, thank you.
Yeah. A few words from you as you joined way away from Canada. Kulin bhai.
Yeah. Thank you very much, Jaga Seth, for acknowledging me from the Canada. સર અત્યારે રાત્રે 3:30 થયા છે, હું તમને ખ્યાલનો સાંભળી રહેલો છું. -10 ડિગ્રી વાંચતા સાંભળું છું તમને ત્યારનું. You have did excellent elaboration, sir. And only wish we would like to see you in the High Courts and Supreme Court, sir, as a judge. Thank you very much, sir.
તમે કેનેડાથી આવી વિશ ના મોકલો.
Thank you very much. Because you are the proper person, you are the most.
મારી એજ જતી રહી સાહેબ, હવે હું નહીં કહી શકું. Sorry to disappoint.
No. Sir, you did excellent, sir. And જ્યારે તુષારભાઈને આપને સાંભળી છે ત્યારે બીજું કંઈ સાંભળવાનું હોતું જ નથી. તો once again, thank you all the association, AGFTC, ITAT, SGITBA and SGCCI. Thank you for Jaga Seth. Thank you very much, sir.
Yeah, thank you very much, Kulin bhai. Joining from Bay Away, you will get the award of being the most studious because you are from Canada.
Thank you very much.
After deliberation by Tushar bhai on this very important Bansal judgment, which in other language can be called Tariq pe Tariq judgment, Southern Gujarat Chamber of Commerce and Industry with all the other organizations would definitely come down with a same seminar on some other topic, that is DTVSV, the Direct Tax Vivad Se Vishwas scheme. Till then, over to Viresh Rudalal for final vote of thanks.
Thank you so much, Pragnesh bhai. And I would like to thank the Southern Gujarat Chamber of Commerce for taking lead of this nice conversation. And we have none other than the very reputed now at the level of India level, Pan-India, sir. You are now Tushar Hemani, sir. As Supreme Court says, Pan-India level now you are having an entry. And I would like to thank the Pragnesh bhai, Suresh bhai Kabra, Anil bhai, Kishore bhai, Deepesh bhai, the very young dynamic, Ashish bhai, Nitesh bhai, all present here, the stalwarts, and all the association joining. First of all, the parent association, SGCCI. Thereafter, sir, our Institute of Chartered Accountants, the ITAT Bar Association, Surat, Sir, South Gujarat Income Tax Bar Association, All Gujarat Federation of Tax Consultant, CGCTC, and the remaining association, which I can't now forget. So all these association now are joining and hearing this case. Because, sir, the arranging this is definitely, sir, we have a takeover from your, because all the three compartments you have very nicely bifurcated the things. The firstly, the 13, 14, 14, 15. Thereafter, sir, you have bifurcated sanction aspect on 16, 17 and 17, 18. And thereafter, you have nicely deliberated on 15, 16, sir. So I think we are much satisfied, and we will like to take some course of action or some action in our cases which we are handling, sir. And as we meet you at the Gujarat High Court, you are always, sir, very cooperative and very courteous to us as a junior person. You are guiding. Sometimes the judges are very irritant to us, but you are such a helping hand to us, sir, that we get so much knowledge and so much inspiration from you, sir, seeing you at the Gujarat High Court. So with this, sir, I thank you so much. And we would again like to see your face again on some issues on the third round of this litigation, sir. Thank you so much.
Thank you very much.
Thank you very much for a wonderful vote of thanks. And from the Southern Gujarat Chamber of Commerce and Industry and all the other organization, we wish everybody a happy Diwali and a very prosperous New Year. Stay safe and stay litigation free. Thank you very much.
Happy Diwali. Thank you.
Yeah, but